I'm Andy Acantelo. I'm the founder of the Transparency Task Force, which is a certified social enterprise dedicated to driving up the levels of transparency in financial services. We have about 14 campaigns on the go. We're obviously not coping with that, but we have somehow got 14 campaigns on the go. One of them is the Woodford campaign group. Okay, so please understand this is one of several such campaigns we have on the go. When it became very clear that there seemed to not be a representative group sticking up for the Woodford investors that weren't part of a legal claim, for example, Lead RGL, Parker's Parker, we formed the view that it made sense to create a forum, a safe environment where people can talk about ideas and issues that may or may not be in keeping with a particular legal claim. That idea morphed through into the Woodford Campaign Group. The Woodford Campaign Group meets on a monthly basis. It's for Transparency Task Force members, and any of you are welcome to become a Woodford Campaign Group member. It's not free. We're asking people to make a contribution each month. You're free to contribute any amount from £100 per month down to £1 a month. We're clearly not doing this for commercial reasons. I'm not operating the Transparency Task Force in a commercial way at all, but we literally have Woodford Campaign Group members who are paying £1 a month. It's more about the thought than anything else, and a recognition that we can't do what we're doing for free. So please do participate in the Woodford Campaign Group if you want to. You'll need to pay somewhere between £100 a month and £1 a month to participate in those monthly meetings. But if you don't want to participate in those monthly meetings, that's fine. You can still get the Transparency Times for free, which is our weekly newsletter, and you can still join the Facebook group that we run for the Woodford Campaign Group if you want to. There's no cost on that at all. So you've got choices. I'm not trying to shoehorn you into something. I'm just making you aware of the rules of the game, so to speak. Okay, so let me look at the chat and see if anybody apart from myself and Mr. Mark Bishop want to talk or want to ask me questions. So far, the answer is no. Okay, I'm going to invite Mark Bishop to provide a bit of an executive summary around what happened today. And Mark, regardless of whether we agree with it or not, or like it or not, could you please, as succinctly as you can and as clearly as you can, explain in essence what the legal argument was for why there shouldn't be two or more classes? So please, Mark, just share with everybody your reflections on today. Don't go into the pieces we discovered that we discussed with the judge in terms of our bit when we had a chance to speak. Just cover everything up until you and I speak, please. Thank you, Mark. Thank you.
Okay, so there were two parts to today's session. The first part of it was her handing down her judgment about the most significant issue that was debated on Tuesday, which was whether there should effectively be two votes, votes of two classes of investor, the private investors and the institutional ones. This question was important because the institutional investors, of course, have a lot of votes. And if we assume a low level of participation from the private investors, it's wholly possible that if there's only one category of voters, the institutions will decide what happens, because they may well cast more votes than all of the private voters together. She decided that there should not be two classes of voter, and in a minute I'll describe why. The second part of the hearing was to cover other stuff, and she made it very clear that the other stuff could only be what she called process issues. So process issues are about how things would run from here on in relation to the scheme of arrangement. So it could cover things like the detail of the voting and so on. So just to return to the first of those things, which is why she came to the decision she did about there being only one class of voter. Now, she did that because of a legal precedent. I'm going to stress, of course, I'm not a lawyer. So anything that I think I know about the law, don't rely on it. It's what I think I know. It's an opinion. It's not a fact. But it seems to me that when there's a legal precedent, which means a case has happened before, anything but a very senior court has to follow it. A senior court can overturn it, but that's a big issue. I don't think this court is senior enough to overturn an existing precedent. So the existing precedent she quoted had to do with the insolvency or proposed insolvency of a company. And the company had two classes of creditor, employees and people who weren't employees. And the employees had different rights and interests because as employees, they could get money from the state in terms of any unpaid salary up to a certain level. So what she said is that in that previous case, a judge had decided that what matters in deciding whether or not people should be regarded as a separate category of creditor is on two things. The first is, do they have the same or different rights in respect of the insolvency? So would their claims against the insolvent state be treated differently? And the second one was, would they be treated differently by the scheme of arrangement if it goes ahead? Now, it is abundantly clear that the creditors, as creditors, are all treated the same. If the firm became insolvent, you'd all get X pence in the pound, and the same outcome would happen for the institutions. Would you be treated the same by the scheme of arrangement? Yes, because it would distribute money exactly in proportion to the shareholdings of each of those holders, whether private or institutional. So what she basically said is it's quite possible for a person to have different legal rights and entitlements, but that doesn't matter in terms of the decision about whether they are different classes of creditor. So you have different rights than an institutional investor because you may well be eligible for redress from the FSCS. She acknowledges that this is true, but she also says it's not relevant. So that's how she reached the decision she did. And having heard her say it, I have to say I think she was right to reach that decision. It may not be morally right. It may be that actually there is a case for overturning the precedent that exists. But unless you're going to crowdfund, £500,000 of lawyers to go to the next tier of court above this one for an uncertain outcome, I think you have to accept that the decision was correct in its interpretation of the precedent that exists. So that was the main thing we covered. And then we covered everything else. And the everything else is really about the process of this thing happening. The main area of discussion about the process actually had to do with the timeline, when everything's going to happen. And because there was a need to do quite a lot of work to the documentation, the lawyers wanted more time. And for that reason, a slightly different set of deadlines has been issued. And they, in a way, they don't really need to concern any of us unduly because people will have the same amount of time to vote. So it's not really significant either way for us. You could say it's slightly significant because creditors might have to wait another 10 days to get their money, but in all other respects, and that's of course only if the scheme of arrangement proceeds. In all other respects, it doesn't make a difference. So other matters that were dealt with that were about process were, small things about, how the vote would be organised, what to do about a person who has either died or handed their shareholding to somebody else, a person who can't vote online or in person because of a disability or vulnerability, and then things to do with the documentation, particularly in respect of the I think it's called, the accompanying letter. I can't remember what it's called, its official name, but the thing that basically sets out why they think that you should accept this deal and what the alternatives are to the deal. And it was mostly at that point that we came in. But really the most significant thing that we learned during all of this is that explanatory letter, thank you, Neil. Neil's put it in chat, explanatory letter, or explanatory statement. I think both phrases have been used. But the main thing that came out of it is that the hearing today is not a binary hearing in regard of all of these process things. She wasn't making decisions about the things that people were talking about. She was expressing some opinions about them, trying to guide people down a particular path. So, for example, if we said the explanatory letter needs to be much clearer about the counterfactuals, she would say, actually, I sympathise with that view. Would you guys think about how you can strengthen this area as a recommendation? But actually, the reason why she was making a recommendation is that what will happen effectively after the voting and stuff is another hearing, which is called a sanction hearing. This is a hearing where they decide whether to sanction the vote. In other words, to endorse it as a thing that will actually happen. And at that hearing, we and other people have the right to turn up and say, we don't think it's adequate. We don't think that this should go and be enacted for the following reasons. So effectively what she's doing, she's creating this hostage to fortune, whereby if those things don't get changed that she thinks should be changed, then that might open the door to a challenge to the scheme in this second hearing. And that one, I think, is going to be something like the 14th or 18th of January. It's mid-Jan. So it's a little way into the future.
Mark, thank you very, very much indeed. Thank you. Before we go on to what Mark and I spoke about, does anybody have any comments or questions relating to what Justice Bacon spoke about today? Neil Taylor has very helpfully put 18th of January 2024 in, and I believe I'm right in saying, Neil, that's the date of the actual sanction meeting. Okay. Does anybody listen to it or watch it either in person or online? Wow. Wow. I'm going to go to gallery view so I can see everybody. Neil, let's get your thoughts then. So you watched both. Neil, reflections from you in terms of what Justice Bacon talked about today, in addition to anything that Mark has already said. Neil, to you, please. Thank you.
Yes, I watched both hearings, the one on the 10th and the follow-up one, the hybrid. They called it a hybrid meeting or a et tempore, which means that they're going to make the decision vocally at the meeting, and they did. The main issue was the classification, which everybody was driving for, to keep retail investors separated from institutional, which it wasn't granted. So we have to accept that and move forward, and it's not going to change now. The other point, she was, appreciative of everybody's efforts, and particularly getting the detail right. She was quite keen that they did communicate properly and try and improve that. I think sending out all those documents 2 days before another meeting and they're all draft, didn't necessarily help everybody, because I think everybody went into panic mode to do things, but it was a bit of a rush of blood, I think, and it had some good points, but it had some bad points from it, I believe. My feelings is that the voting will be limited by the retail investors, and we need to try and make sure that they get the communications are better and improved, and that we can sort of get them to voice their opinion clearly, because it's a key issue really for everybody who's invested, I think. And that's the key thing I think we need to try and do, somehow get everybody to realize what's going on, and only on the top level. You don't need to know all the micro details, a huge amount of detail, but it really isn't that complicated. It's you either accept the scheme or don't accept it, and you've got to look at the two values that could happen, and what the impact, what is the side effects of the scheme being accepted. One of them is that you give up your rights to financial services compensation scheme, which is the biggest danger in this, I think, all the way along. And that's the thing that bothers me, because that's what they put it in there. So I think the the lawyers, I'm going to meet up with the lawyers tomorrow. So I'm on the claimants committee with Lee Day. So we've got a meeting tomorrow with them just to see what their steps are, similar to what strategy of TTFs will be, what we're going to do next. What can we do next to make sure that everybody gets a fair vote.
Neil, thank you very much. Very, 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 very helpful indeed. I see that Jeremy Klein's put the comment in. What part of the comment is, he's put it in the chat. Unfortunately, the sound broke down halfway through the judgment. Really disappointed to hear that. So, Jeremy, if you can, please take yourself off mute and just explain your thoughts on what you heard up until that point. Any comments, Jeremy?
Can you hear me?
Yes, we can. Yeah.
Okay. Well, it was just that. I mean, it was. We heard most of the judgment. I mean, initially there was until they sorted it out, and there was a period where nobody could hear anything online. Then it was sorted out, and then all of a sudden, about halfway through, it went completely before they restored it. So I don't know what was said during that. That was rather disappointing. But I got the feeling from her that she was trying to press things forward in terms of getting things concluded so that or the monies available wasn't whittled down through being spent on lawyers' fees. I don't know if I judged that correctly, but well done to those who spoke up, Andy and Mark. I have to say, thank you for that.
Thank you, Jeremy, and certainly thank you, Mark, and everybody else has been working very, very hard in the last week or so, if not 2-3 weeks on this. Particularly Alan Hyatt, who we'll hear from in a minute, Neil Taylor, Graham. I think Graham's with us as well. We'll go to Mark Bishop, who just raised his hand, and we'll ask Graham to share any thoughts he had if he was watching it today. Mark, thank you.
Well, thank you. I'd just like to respond to what Neil said, because Neil raised the issue of participation. And really, that's linked to the question of communication. And the problem is this, and we know it, that many of the investors have not been contacted by the platforms through which they invested, and those who have been contacted by those platforms have been contacted in such a way that maybe they didn't understand the significance of what they were being sent, and so they didn't respond to it. We know that as of, I think, the end of last week, only 19,000 people had downloaded the practice statement letter. So that's less than 10% of investors. We learned something interesting, which is that the fund has only ever had 113, I think I'm right in saying, investors. Technically, that's direct investors. And the reason why there appears to be only 113 is because Hargreaves Lansdown would count as one, AJ Bell would count as another. So the platforms themselves each count as one investor, even if they've got 100,000 people in the scheme. So there are 90 platforms through which people invested. And that's why there is a problem, because under GDPR, the platforms cannot hand the names of the Woodford investors to Link and say to Link, there you go, contact them at their email address, write to them at their home address. They are simply not allowed to do it. So one of the challenges for Link is that they've got to hope that the platforms do a better job of communicating to consumers. And the judge basically said to the FCA, you've got to do a better job of trying to persuade these platforms to communicate. Now, here is, and I'm going to sound a little Machiavellian here, here is the kernel of an opportunity for us. I think that the FCA is probably not going to try too hard to persuade the platforms, because it would quite like a situation in which not too many private investors vote, but all the institutions do, because that way a very high proportion of the investors will vote for the scheme at the total votes cast. However, the opportunity for us could be to go to the sanction hearing and say, you know, there are 250,000 individual private investors. Of those, 15,000, 20,000 have voted. That is maybe 7%. Of that 7%, let's say 2/3 voted for the scheme. That's 5% of the total. Can it possibly be in the interests of natural justice that 5% of the private creditors can bind the hands of 95% of the private creditors, particularly when, if the scheme takes effect, it has some very draconian effects on their ability to claim against the firm, again, not just in respect of this, but in respect of anything, to claim against the FSCS. All of those rights are taken away from them. That does seem very unfair. So actually, this kind of structural challenge, which is about the impossibility of communicating direct with the investors, could actually turn into something we might be able to use to our advantage at the sanction hearing.
Mark, thank you very much. Mark, I'm going to make a quick point or two. Then please go answer the question Lisa Harness put in the chat, which I think you've effectively just answered, but I'd like you to confirm your thoughts on the question Lisa put in the chat a few moments ago. While Mark's reading that, I'll talk about what I tried to do when I was given the chance to speak. I tried to make the point that in the Investor Advocate's report, there's reference to the idea that the scheme has to be fair. And there's a part of the paperwork, I think it's the top of page 15, I think it is, if I remember rightly, where it talks about the idea that the scheme must not have a blot in it, a flaw. And I tried to make the point, as effectively as I could, that the scheme must have a flaw if the scheme is unfair. And I talked about the unfairness, that there's been a grotesque lack of representation of the investors' interests. Of course, there are those who are being represented by Lead A, and there are those who are being represented by Harkers Parker and RGL, but there's 100,000 plus people who aren't in either of those schemes for one reason or another. That's not a debate for today. And we simply try to make the point that moving forward, i.e. between now and the sanction hearing on the 18th of January 24, there ought to be much, 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 much better representation of the investors. So we were very pleased, I was very pleased that Judge Bacon seemed very comfortable with the idea that the Woodford Campaign Group now liaises directly with the court without having to go through either the investor committee, which frankly I don't trust, because it's people running it are being paid for by Link, and the investor advocate, who frankly I don't trust because he is being paid for by Link. So from our point of view, I think the win today is that we've effectively created an opportunity to engage directly with the court in a recognised way. Over the next few days, we're going to be cogitating how to realise the potential of the Woodford Campaign Group as an organised fighting force on behalf of all Woodford investors, not just those in Link or not just those in RGL or Harkers Parker or Lead A, but everybody. So we'll be looking to organise a leadership team for the Woodford Campaign Group. We'll be organising the assignment of responsibilities. We'll probably be creating a website, so on and so forth, so on and so forth. There'll be people with Woodford Campaign Group email signatures, so we can actually formally represent the members of the Woodford Campaign Group in a kind of formal way directly with the court. That's where my thoughts are going. What this means from my point of view is that we have, I hope, created an opportunity of liaising in a far more direct way with the court rather than going through the investor committee or the investor advocates, neither of which, for reasons I won't bore you with, I have any trust or confidence in. That's essentially what I try to do, and Mark will talk about the points that he raised in a short while. But before we go to those other points, Mark, if any, could you please respond to the question that Lisa put in the chat? Because I frankly think Lisa's question is hyper important, Mark.
Yeah, I might actually, if it's okay, just quickly reply to several. So the first one was, Here we are. So here we are. Okay, so Graham has asked a question about whether it's true that Lead A can take 30% of the award. I haven't seen the Lead A contract, and I'm not a lawyer, so the honest answer is I don't know. You'd have to look at the wording of the contract, and if there was doubt, you'd have to get a legal opinion. It seems to me that if the answer is yes, then that could be another reason to vote against the scheme, because if you're going to have to give away 30% of it, then there may be more benefit or more importance to trying to make it a larger sum of money. So that's the first point. The next one is Lisa. If an individual votes against the scheme but the majority vote for, does the individual that voted against lose all their rights to the 85k from the FSCS? Definitely. Again, I'm not a lawyer, but my personal opinion, rather than legal advice, is yes. In fact, it's even worse than that. It's quite possible that the majority of private investors who vote, and there may be very few of them voting, may vote against the scheme. But as long as 75% by value of the votes cast are for the scheme, then unfortunately you are bound by the scheme. And that means you're ineligible for FSCS, for redress scheme, litigation, all of that. Your rights fall away in respect of those things. So that's why we're trying to get, or hopefully we're going to try and get some kind of threshold put in, or more likely try and get the thing rejected because there wasn't a decent number. Next one, Lisa has also asked, if the scheme goes ahead, can investors still take action against Hargreaves Lansdown? I'm not a lawyer. I can't tell you the answer to that question. I haven't seen anything personally as a non-lawyer that makes me believe that that is the case. And I also don't think that other courses of action, whether they're litigation or their enforcement action by the FCA, would be taken out of the mix. The problem is more that we might fear that the FCA might, having got this, scheme through, not have the appetite for others. But that's purely speculation. Nobody knows.
Mark, thank you. There might be one or two others in the chat. Please take a moment to have a read of those while we go to Mr. Alan Pyatt, who's got some thoughts about the publicity side of things. Alan.
Right, a couple of things. So I was presenting on Tuesday, rather long day. I'd like to catch up on a few things. Going back to what Mark was saying, it is all about communications. I mean, we need to get the campaign group bigger. We need to get, 25, 30, if we can get 50,000, but that isn't going to happen, unfortunately. But we do need to get the communication somehow out to the investors. So what I put in the chat earlier, I'm going to contact Alex Brummer of the Daily Mail. He has a section on a Saturday on finance, and really in one of those, in that area, he has something called Since You Ask, and I think we need to have in there, get him to do a SOA. What does SOA mean, and what does it mean for the creditors? Because, a lot of people don't understand that if they don't vote or they vote no and the vote gets passed, I think Mark said earlier, we're all binded by it. So it'll all happen to us, and it'll all happen to the 100,000 or plus other people who haven't got a clue this is going on. And as you saw my note to the court this morning, and we've already mentioned it, it's communication. I mean, I'd love to see what the FCA are going to do. I hope they're going to share it like the IA did. So we got the information, we got copies. Well, I got copies which I distributed to yourself and in Mark, etc. We got copies of the communications that went out from Link to all the platforms, and I'm hoping we can do the same. We can get the same from the FCA, and hopefully we've got enough people who are in the different entities like Hargreaves Lansdown, myself, and others, that as soon as the email goes out next week or the week after, we can get copies of that to see what they're actually saying, and see is there, we need at least 10 or 12 examples of the big platforms to say, well, look, they're not really doing it very well from that side of things. I also think it'd be very helpful to understand when we come up to a court hearing, what that court hearing is going to be about. Because this court hearing was mainly about classes and us putting a few things forward. And it's unfortunate we didn't get 2 classes, but we've got to live with it, and get as many people in the army as possible, so people do vote and understand. I've had quite a lot of emails from different people about their situations. One was a brigadier, and they're all a bit confused. And I think we need to manage that somehow, but we need to talk to the masses at once rather than having, individual conversations, because it's just too hard and difficult on individuals.
I agree. The idea for a one-to-many is going to be the only efficient way to go. Something Mark talked to me about earlier today is the importance of us getting some proper legal input ourselves, whether that's pro bono or funding. So one of the things we're going to be looking to do is to see if we can find a lawyer, either for free or for not much, who'll actually help us. So we'll definitely be working on that. Mark, excuse me, folks, it's been a long day, my throat's right. Anything else you've seen in the chat, Mark, that you want to respond to?
I think somebody asked whether you can still sign up to any of the litigations. I think they all closed some time ago, but if anybody knows different, please say. I think somebody said, if there are only 100 or so platforms, which are really the investors in law, how do any of us get a vote? Well, that's not the case. The platforms are the direct participants in the fund, but they are holding as nominees the votes of, or no, not the votes, the money of the investors who are their clients. Those investors are the people empowered to vote. Unless you've signed something that says your platform votes for you, then you have a right to vote. The issue is not so much the right to vote, it is the awareness of the need to vote and having enough information that you feel confident to vote, and that the information is sufficiently impartial that you might consider voting against the scheme if that is the right thing to do.
Can I just mention something there? Something that happened on Tuesday, and I don't know if anybody picked it up, is Lee Day and Harkers Parker said that for about 10 or 11,000 of their clients, their claim would be about 300 million. So if you extrapolate that up to their full number, they've got about 20,000 between them. That's about 500 million. Yeah, so that's quite significant. The other number that's interesting, and that came out on Tuesday, we actually got the evidence of how the FCA managed to compute the £298 million, which was an A-level student could have done better, basically. All they did was said, well, okay, this was the run on Woodford for the previous 7 months. All these people who didn't sell until it closed, how much in total would they be worth? And that's how they came out to the 298 million, which bears no resemblance to the actual losses. It's just a calculation, which is poor. And unfortunately, the company Link has used that to compare what they're offering against what the FCA have said. So the cornerstone of the 298, we really, somehow we should have managed to disparage that somehow. I don't know how we're going to do that. And I think going forward, if it's Justice Bacon, somebody in the court needs to get hold of the Link and their lawyers and stop them deluging or people and other, lawyers, thousands of pages overnight to be read and responded within less than 24 hours. Yeah. And just doing that, it's just ridiculous.
Can I make an observation? Because I've been on this for 3 years.
Yeah, go for it, Anthony.
You might have spotted my name as the lead claimant on the Harkers Parker claim. So I probably can answer some of these questions. The question about paying Lee Day and Harkers Parker, the answer is technically yes, but in practice, it'll be an absolute bastard for them to try and reclaim it from thousands of people. So they're going to have a big problem reclaiming it. In normal circumstances, if there was a settlement, that settlement will be paid to them and they would deduct their percentage and pay the balance on to the investors. But if it's paid directly by Link through the platforms, they would actually have to get each investor individually to pay them, and I think they realised that could be quite difficult. I have to say I can't tell you anything confidential that I know through Harkus Parker, because that's an NDA. It's covered, but most of this is opinion, isn't it? Then there was a question about whether you can sign up, and I think the answer is yes, you can, but I wouldn't do it if I was you, because why would you? The actions are still there, the claimants are still there, and if you're going to get paid out with no deduction, why would you sign up now? I can't see why anybody would sign up now.
So Anthony, all else being equal, one person's in either Lead A or Harkus Parker or RGL, and another person isn't. And if the scheme of arrangement goes through, one person's going to end up with 30% less than another. Is that basically the gist of it?
I think that's the legal position. What the practical position is might be different. Whether they are actually going to sort of take legal action against each of their claimants to claim their 30%, I don't think that would go down very well.
I'm no lawyer, but would it not fundamentally be a breach of contract if one party's agreed to pay another party X under certain circumstances? If those circumstances arise, they're legally liable for it. I mean, to not pay the lawyers, it sounds to me like a really dangerous route to go.
It would be dangerous. Now, I was sitting next to Meryl, who is the lead lawyer on the lead day, and I know that Neil knows her very well. And I mentioned to her, that I was one of their clients. And then would they be after 30%? And she said, definitely going to happen. How they're going to do it is a different matter, but they're definitely after it. And all they'll do is send you a really nasty, snotty letter at the end to say, if you don't do this, we'll take you to court. And a lot of people will just fold then, or, whatever.
I think you're right. Melanie Williams, you just put a very nice thought in the chat there. Melanie says, I contacted Hargreaves about my right to vote as a private investor several times. They were evasive at first. I wrote to them again, and I've had confirmation that I will have the right to after all. Very interesting. Melanie, if you're happy to, please take yourself off mute and introduce yourself and tell us a bit more if you want to, Melanie. You don't have to if you want to. I think Melanie is not so comfortable doing that. That's cool. We'll be
Can we ask a question, though, if she could put it in text? Can she actually say whether she is a direct investor or she's in the multi-manager fund of Hargreaves Lansdowne? That's important.
So Neil's saying all direct investors at Hargreaves can vote. 130,000 voters can, is what Neil's saying. So presumably, Melanie is a direct investor. Melanie, would you be able to confirm that if you're happy to? It'd be a bit of info if you could. While Melanie's thinking about that, let me go to Graham Dickinson. Graham, you spoke on Tuesday. Frankly, you did a great job, as did Alan Pyatt. A really, really good job. And we've obviously interacted a little bit over the last couple of days with each other and what we now call the Woodford 5. Graham, your reflections on today, if you watched it. Any other thoughts, sir?
Can you hear me? Can you hear me now?
Yes, we can.
Okay. I did have some difficulty following it. I had to use my laptop where the sound wasn't great, and I was engaged in decorating my son's house whilst I watched it. I didn't get that much out of it, and I didn't get a chance to participate. I couldn't attract anybody's attention at the end when they asked if anyone had anything to say, because I did want to reiterate that I was deeply worried about the prospect that a minority of voters would bind the majority that didn't vote if that's likely situation arises. So that was a lost opportunity as far as I was concerned. I think the content, Mark covered the content pretty adequately. I haven't really got anything to add to that. And I agree that the most critical factor now is to wake everybody up and make them realize that this is happening. They need to engage with it. And if they're hands off and don't engage, other people are going to make the decision for them and it will bind them. and that message has to be put across somehow.
Grant, thank you very much. My worry, and I'm no doubt some of you are worried about this as well, my worry is that the FCA will comply with the judge's request and ask the platforms to do a much better job of communicating with the investors, but they won't make the platforms do it, and therefore the platforms won't do it because they may not have an interest to do it. So the communication to the investors will continue to be rubbish, and as a consequence of that, there'll be very poor turnout in the votes, and as a consequence of that, we may end up with a situation where a very, very small number of people end up creating a binding situation on nearly 250,000 British investors. And I think somebody made reference to the idea of natural justice earlier. I think it would be absolutely shocking and terrible if that were the case. I really do. I really, really do. And I think reputationally, it would be bad for the FCA, it would be bad for the FSCS, it would be bad for Link, but frankly, they don't seem to, in my opinion, care much about how they look. They seem to want to work to a particular agenda. Many of us do think all this has been a pretty well managed, stage managed, foregone conclusion from the beginning, with the FCA's own conflicts of interest leading it to not particularly support the consumer. And there's lots of reasons, as far as I can see, to be cross about it. Mr. Mark Bishop, and then we'll start bringing things to a close. Mark.
Yes, Andy, so something really interesting has gone on in the chat. Jill Quick was asking whether it's right that Hargreaves Lansdown can vote on her behalf. And initially I said, unless you've signed up for some kind of wealth management service where they basically do everything for you and you just wait for the dividends to roll in, I would be surprised. But she subsequently clarified that she's not a direct investor in the fund. She invested in Hargreaves Lansdown multi-manager fund. And because she's in the multi-manager fund, she's been told, no, the private investors in the multi-manager fund are not going to be allowed to vote. Presumably, either the fund manager will not vote or he will vote on their behalf. Now, if he decides to vote on their behalf, which I have a horrible feeling may well be the plan, then I think I'm right in saying that fund owns about 15% of the Woodford Equity Income Fund. Now, I would be surprised if 15% of the private investors vote. Let's say that at the most 10% vote, at the most. Let's say even 5% vote, somewhere in that kind of region, I think is what you're going to get. And even if they're evenly split in between for and against, actually the people who vote against are going to be wiped out by the 15% block vote for the scheme by the multi-manager fund. So effectively what you get is somebody who doesn't have any shares in the fund themselves, whose firm is conflicted because they are themselves on the receiving end of litigation, who actually perhaps didn't have their client's best interest at heart when they invested in the fund in the first place, and certainly don't have them at heart now, overriding the private investors who may by a small majority be voting to reject this scheme. Because remember, it's 75% by value. And if you've got 5% by value of private investors who are saying we are against the scheme, you've got 15% by value, which happens to be in HLMMF, that are saying we are for the scheme. Suddenly your 75-25 ratio is present, and you've literally only got one fund manager, one guy in a cheap suit who hasn't got any skin in the game himself, has just overridden the private investors, and he's contractually bound those people to the scheme arrangements, taking away the rights of 250,000 people. That is a nightmare scenario, but it's not an implausible one, actually, from the way things are panning out. And I think if that were to happen, I would hope that we would be able to make the case that the vote should be disregarded because it's against natural justice. So in a perverse way, I remain of the view it could help us that not many people vote, because the few people vote.
I'm sorry to interrupt you, Mark, but I don't think it's correct. it was clear that it's 75% by value has to vote
Yes,
for the scheme,
that's what I'm saying.
and 50%, more than 50% of the votes have to be cast in favour of the scheme for the scheme to go through. So I think the multi-manager funds will only have one vote. So I don't see that argument as being totally valid.
Yeah,
If we could,
no.
if we could get enough people to vote again.
Yeah, and Alan, I could be wrong, but I think every share is a vote. So
yeah, so hang on, we've got to be careful here. So
guys, let go. Whoa. We need to manage this carefully. So Mark is speaking. Carry on, Mark.
okay, every share is a vote. So if I own 10 shares,
no, every share is not a vote.
Anthony, please don't interrupt Mark. Okay, the way we play the game here is people take it in turns, and I manage that. Otherwise, we end up with people speaking over each other, and that can be counterproductive. Mark, carry on, please.
So I mean, I stress I'm not a lawyer, but my reading of the scheme paperwork is that you're absolutely right. 50% by volume of the votes cast must be for the scheme, and 75% by value. So there is this question about whether, you know, a large number of votes. I mean, it is possible, of course, it is possible that, you know, a large number of private investors could outweigh the others. But the problem is, if you've got a large number of investors or equal numbers of investors, do you see what I mean? You've got, let's say you've got out of 250,000 investors, 10% of them vote. So you've got 12,500 one way, 12,500 another way. Those are equal numbers. If you then get an institutional investor who turns up with a vote for the scheme, you're over the 50% volume, and you're also over the 75% value. That's the problem. So I have a horrible feeling this could happen.
Thank you. Thank you very much, Mark. Anthony, please take yourself off mute and share your thought. Thank you.
Sorry about being passionate about it. It is clear to me, and I've been involved in this for a very long time, that each investor gets one vote, and it doesn't matter how many shares they have, that's one vote. But when it comes to the second computation, which is what is the value of the total vote, then the number of shares they have does matter. So if I've got 10,000 shares, I get one vote, but the value of my 10,000 shares goes to the computation of the 75%.
Thank you, Anthony, for sharing your thoughts. And Alan, you wanted to come in as well. Go for it, please. Thank you.
No, I was about to say the same. I'm trying to find what the investor advocate actually gave us a response in our template about this. So I'm just trying to find it, and when I find it, I'll stick it in the text in the chat. So I'll find it first. I'm just looking for it now.
That's helpful. Thank you very much indeed. All right. So even at this stage, there seem to be some grey areas around people's understanding of what the rules of the game are as far as the voting is concerned, which to my mind just reinforces the point that we've all been making all along, which is the communication's been pretty down there. We will be wrapping up shortly. I want to just give Alan the chance to find the document or the response he's looking for. Alan's very organised. I'm sure that won't take too long. Does anybody else have any other comments or questions before we start bringing things to a close? Neil Taylor, could you please vocalise the point you just put in the chat? That looks very interesting indeed. Neil, come back onto the mic if you could, and then we'll go to Michael McNulty, who I've just seen his hand going up. Mr. Neil Taylor, please bring to life.
Thanks, everyone. I think the discussion is quite heated around multi-manager funds. In the contract, it does say that the first fund will be the people who vote, which will be obviously at Hargreaves Lansdown, because they manage the fund, which has got 10 or 12 investments in it. But what we were trying to do is to say that Hargreaves shouldn't really be allowed to vote because they've got pending litigation against them and all these type of things, and that the individual MFU holder of Hargreaves Lansdown should be able to acquire that vote by some proxy vote transfer to them or something like that. And that's what we were trying to get Clifford Chance to realise, but they sort of brush over that and just say these are the rules we've set. This is what we're going to do. So it looks like they've got the power to vote. I mean, they've had one vote, but it'd be worth 519 million possibly, because that's what the ticket is worth, and they're going to use the values as the worth. And so that is the worry, and it might be a good idea if we can approach Hargreaves, some MFU people, check it and see if we can find out whether we can proxy vote it to the individuals, because that'll be much better if that could happen. But it does take time to do this.
It certainly would. This is definitely going to be a red flag that we start waving vociferously. Mr. Alan Pyatt, in his organised, as always, self, has found the comment. We'll be giving everybody a chance to look at what Alan put in the chat, and I'll invite those who've spoken about this matter to comment on what Alan's put in the chat. We're going to now go to Mr. Michael McNulty. Michael, please take yourself off mute. Thank you.
Hi, Andy. My thought is, I'm with Lee Day.
Yeah.
So shouldn't I just, if they're going to take 30% of the of whatever the benefit might be, shouldn't I just wait and take their advice?
Of course you could. Yes, of course you could.
And also, I don't know how many thousand investors they've got on their books anyway, but said that surely that there must be a weighting there that might affect other stuff.
Yeah, they could. And I guess part of your thought process might be whether or not you feel the law firms Lee Day, RGL, Harkers Parker are, under some circumstances, pulled in one direction commercially compared to their clients because of the issue around the FSCS. Give that some thought, Michael. So, Alan, please talk to what you just put in the chat. How do you interpret that response from the investor advocate? Thank you.
Well, yes. I mean, I've just seen what Keith said as well. He's got holdings in a SIP and ISA, etc. But it does say each screen creditor. So you might have, 3 different holdings on 3 different platforms, but you're the same person. So you would only get 1 vote, I would suggest, even though you've got shares in WEF from 3 different platforms or 3 different types of investment vehicles like SIPs and ISAs. And then, as Anthony said, it then becomes what your value is that goes into the value pot. So if you've got £50,000 worth, you're putting in £50,000 of value into the 75%, as it were.
Yeah. And
as Neil quite rightly said as well, Hargreaves Lansdowne is the big issue that we need to overcome.
And that's the inherent conflict of interest in the whole damn thing. Neil, thank you for putting those numbers in the chat. That's really good to know. Mr. Mark Bishop, back to you, sir, and then we'll start bringing things to a close. Mark.
And I think just to deal with this business about the 50% and 75% thresholds, in a way, I think that the word votes is not that helpful. How many votes do you have? In a way, you don't have any. It might be more useful to think about how many people vote one way or another, and how many shares or what value of shares are voted one way or another. So I am one person, even if I have, a dealing account, an ISA, and a SIP, and even if I have those in 3 different platforms, that isn't 9 people; it's 1 person. So if I vote for the scheme, and I don't know, Alan votes against the scheme, we have equal weight when counting how many people voted for or against the scheme. Now, it might be that he has a greater value of shares across all his accounts than I have, in which case, when it comes to counting the value, he is going to help get his side towards a target more than I'm going to help mine. So I think that's what they're trying to get at. The language is imperfect, but that's what it's about. So the problem for the private investors is that a platform or an institutional shareholder is only one person in inverted commas, but they may have a very large value of votes. So we may need to get into an argument that says, well, actually, there is here a very poor level of representation of the private investors. The private investors are not decisively backing this scheme, or they may not be backing it at all. But unfortunately, they are about to have a load of rights taken away from them because of the large value of some institutional shareholdings that may be small in terms of the number of those institutions.
And your comment just now, Mark, takes me to a conversation you and I had months and months and months ago about this very matter. And we kind of figured that maybe the whole thing's kind of rigged against the ordinary individual investor. Folks, we're going to start bringing things to a close. Let me draw your attention to a few potential action points if you choose to act on them. One is join the Facebook group if you haven't already. To my mind, that's a no-brainer. Free comms, free use of information, free opportunity to share thoughts and ideas. Two, if you want to become a member of the Woodford campaign group, then, as I've explained, commit to paying an amount of money between £100 a month and £1 a month, and you can become a member of the Woodford campaign group, which through TTF is going to be acting as effectively as we can to engage directly with the court, not through the investor advocate or the investment committee for reasons I commented on earlier. I think that's about everything. Let's hope we can do something on the media front. That is very, very important. Alan's had a cracking idea in terms of that gentleman from the Daily Mail, I think it was. We've got quite a few contacts in the media side of things. A chap from Investment Week wrote a piece already today, so we'll try and get the word out there. But in reality, I personally think that unless the court makes the FCA make the platforms do the heavy lifting on the comms is going to continue to be poor, and as a consequence, there's no chance the individual investors are going to outmuscle the might of the institutionals. That's my personal reading of it, and I suspect this whole outcome has been managed from the start.
Rigged. Andy, can I say, I've just put something in the chat.
What is it?
So the share class survey, we've currently got over 240 people have responded. If anybody on this call hasn't done the share class survey, which takes a couple of minutes to do, the link's just gone in the chat. If you click on that, it will take you to it.
Yeah.
Thank you.
Alan, for GDPR reasons, I've just deleted it. I'll explain later, Alan. So we're going to wrap it up there, and we'll get the comms out tomorrow or the day after, letting you know what you've been doing in terms of involvement with this community. And let's just continue to try looking after each other as best as we can. Can I please, very, very final thought, and this is meant so sincerely, can I please ask everybody to put your hands together and thank Alan Pyatt, Graham Dickinson, Mark Bishop, and a few others whose names may have escaped me, forgive me if that is the case, who've been putting in a phenomenal amount of work over the last few weeks, and particularly the last 3 days. It's been tremendous. And remember, folks, these are not people who are getting, £500 an hour lawyer fees. They're all on an hourly rate of zero. Everybody a volunteer. So thank you very much indeed, Graham, Alan, Mark, in particular. Mark's battles on all kinds of fronts for the TTF. So that's where we are on that. Okay, cheers, guys. Thank you very much. Have a good rest of your evening.
Thank you.